Mr Chair, I move that the question be now put.
No, I'll hear about the thesis from Grant Robertson.
Thank you very much, Mr Chair. It will take somewhat longer than 5 minutes to read it, but I'm sure an extension of time will be granted by the House, who will be no doubt enthralled by it. It was a dissertation. I shouldn't overstate what it was, but yes, I'm sure it's been one of the highest interloans from the University of Otago Library they've ever had. Mr Chair, I want to talk about two additional clauses that are being proposed by the Labour Party. In particular, I want to talk about Clause 10 in the name of Trevor Mallard, which is an issue that was raised numerous times during the Select Committee process, and that was around the question of
Clause 9. We can't talk about Clause 10, we're not on it. We're on Clause 9.
Clause 9. Thank you, Mr Chair. I'll return to Clause 10 in the future, I hope. That's right. The other matter that I want to raise is around Clause 9, and it is again around the question of the timing of the transitional provisions. I do note that there's been a wide-ranging debate on Clause 9, and that's a good thing, because the act of transitioning to this proposed new regime is a significant act, and it impacts on everything that student associations do. And one of the things it does impact on is the ability of student associations to communicate with their members, to be able to get across to members what services are provided and what additional services could be provided in the future if student associations were allowed to carry on. And unfortunately, because of the unwillingness of both the member and the chair and also the National Party to actually consider bringing this bill in an orderly fashion, we now have student associations faced, as I mentioned before, like Nelson Melborough, with a situation of students who are, or the enrolment forms for students that are already they've already been printed, about to be sent out, have the fees that they have to pay on them. What's going to happen now to those institutions that are like that? And the Polytechnic student associations do play a very important role in their institutions. One of the nature of student associations and universities is that people will perhaps take 2 to 3 years of time on a student association contributing. They're often at the institution for 3 to 4 years. There is some institutional memory, some continuity. In Polytechnic student associations, people are often there for quite a short period of time, only courses perhaps of 6 months or even less in some cases, maybe a year, maybe 2 years. And so one of the things that Polytechnic student associations do is create themselves in a way that they can provide some continuity for members. That continuity is at risk with the absence of a decent transition or provision in this law, because those associations have, as I said in an earlier call, constitutional arrangements that actually mean that they need to make changes to be able to continue to operate as they do now. And I think the institutions themselves, as we know from the submissions they made, really will struggle to be able to put in place those services for students immediately upon the passing of this bill, if that's what happens. And so, Mr Chair, Clause 9 is inadequate. It does not allow for the different nature of student associations, which has been a feature, I might say, of this bill, and really does cut to the heart of the fact that this is an ideological crusade, because it's an ideological crusade against university students' associations on behalf of those who have issues with some of the political stances that have been taken by student associations. That's what this boils down to. And it really does ignore, in many ways, the role of Polytechnic student associations, many of whom are not going to be able to negotiate the service agreements that some of the university student associations will. Fundamentally, the absence of a proper transition clause re-emphasises the ideological nature of this bill. It re-emphasises the taking away of student decision-making rights in what will be provided for students in the future. And so, Mr Chair, it is a real shame, and I know I've exhausted my calls on Clause 9 in this call. It is a real shame that in debating out Clause 9, we haven't heard a single peep out of the National Party to justify their support for this bill. Not a single peep. There we go. Simon Bridges' best contribution of the year, the word peep. That's it. We haven't heard a single thing from the National Party to justify their support for this bill, other than Mr Hennerei's interjections, and they're not actually justifications, they're more kind of the sounds. They may be words, they're certainly sounds, but that's all we've heard from the National Party. We have not heard from them an actual justification for this, because they know from the submissions that they heard in the Select Committee that this bill should not pass. I've been listening, Louise Upson said they've been listening, I've been listening to a lot of speeches in this debate, and they have come from this side of the House and occasionally from Heather Roy, but they certainly haven't come from the National Party to justify why they are passing a bill that will destroy student associations.
The question is that Clause 9 stand part. We have a number of amendments. The first amendment in the name of Grant Robertson.